point formals as pointed because our Lordship has seen enough of this case. First, I heard Mr. Mehta say time and again, the law granted it and the law took it away. It's like the biblical dictum, the Lord granteth, the Lord takes away. Unfortunately, laws can't act like the Lord. Well, it's the sentence that Waqf-by-user, the law granted, the law took away, is the fundamental fallacy on concept. Your Lordship's basic jurisprudence is that legislation does not create Waqf-by-user. Cannot. It recognizes Waqf-by-user. So the very fundamental point conceptually is wrong because you recognize, you don't create by legislation, there's nothing to take away because you are not the creator. Related to this, this recognition of an essential Islamic concept is not by legislation but part of the corpus, is itself recognized in para 1134.
That is what even Mr. Dwivedi also argued.
Yes, I'm on that repeated thing that what the law gave, law can take away. I'm now on 2R. That's the context in which Mr. Mehta made that point. I'm not on, Mr. Dwivedi got it right, contrary to Mr. Mehta. I'm disputing Mr. Mehta. Number two. So therefore, there is no question of taking away something which you never gave. And the paragraph is 1134 of Ram Janmabhoomi Law should be seen in the other context, but 1134. Number two, this registration is an important, it's actually a connected aspect. Now, registration did exist earlier. That's not the point at all. The point is, whether the arc you have created in this new act of taking away the status of an entity in the absence of registration existed anywhere. That is where, with great respect, the Union of India is not quite correct. In fact, grossly wrong. Registration was there. It required mostly petty penalties. Later on 3 months and then 6 months imprisonment. Now, as the point I'm making is that there is, just see 36.1 very quickly. 36.1 I should have seen many times. 36.1 says that every waqf, whether before or after, shall be registered. There's a connecting arc here which I want to emphasize, which is in a different facet. So 36.1, every waqf, whether created before or after the commencement, shall be registered. Before or after. So in perpetuity before and always after. Now, since, first of all, I'm just giving it point form because this connects very interestingly to 36.7, 10 and 2 surveys. That's the connection I want to make. This is a vicious circle. This draft, this act, makes that vicious circle complete and impossible of compliance. Now 36.1 says, any time before, in the hoary past, now and continuing. Now, Waqf-by-user has been abolished by the same thing, the same act in 2R. So, Waqf-by-user having been abolished can't be registered. Your Lordships can't have a registration of what the same act abolishes. The same act abolishes it. Then we go further. So, one is, everything should be registered. Second is, I abolished one category, so you can't register it. Third, then becomes a impossibility of compliance arc in 36.7a and 10, which give your Lordship 3 months and 10 months. For something you can't comply. It's an amazing structure.
Sorry, I didn't get it.
Yes, this is important. So, this facet I wanted to emphasize has not been put like this before. The original thing says, any time created or any time later, there must be registration. In the same breath, it says, Waqf-by-users abolished 2R. Not sure we've seen that deletion.
2R.
You can't register something which is abolished, fellas.
Why? If you read it harmoniously,
no,
you can't see the provision of a statute in isolation.
No, what is abolished can't be. What they've given is a saving proviso, which I'll come to. They've given a saving where they put a caveat of dispute. I'm coming to that. Per se in concept.
Can't it be read in such a manner if you read 3R, 3D?
Therefore, I'll just come to this.
Harmoniously.
I will.
That even in case of the works which are, yes. The works which are
3R,
which are not registered.
3R
given a breather of a particular period.
3R tries to given earlier. 3R tries to give a saving,
was given earlier,
which I am coming to.
As a last window.
3R does give some saving, whereas I am saying something else. I am developing it. 36.1, having told your Lordship this, then says that do something in X months or Y months under 7A, 8 and 10. Now turn to 7A. So 7A is the starting of that process, receive an application and do X, Y, Z. My Lord has got, sorry, 7, not 7A, 7. My Lord has got 7. 7 is received the application. Now come to 7A. He mentions that this is government property. The same registration with 36.1 requires shall be stopped. Whereas the collector has to mention, allege, think, state, 7A will stop the entire process of 36(1). By whom? Not by a court, not by a tribunal, by a collector. And the previous page says it is mandatory. You must register. Now come to 10. My learned friend says that this is similar to Provision in Trust Act, etc. Not at all. I don't know whether my learned friend should or should the Bombay Trust Act that provision. It's a two-line provision. Now, no resemblance to 3610. 3610 says that you cannot register after 6 months. By the way, this 6 months expires in November 2025. November 2025, the 6 months expires.
Prospective.
You cannot, sir, that's not, Mr. Mehta's on-the-spot benevolence will not rewrite the statute.
No, November 2025.
He can have all kinds of, he can have all kinds of savings of his own.
No.
But that saving will not rewrite the statute.
That's the only way.
Now, very well, how it will be read will be by the court, not by you and me.
But from where do you get November 25?
6 months? Says so. Now, one more sentence, the arc is complete. With this, my learned friend's counter says, you can't register now because we never found you the survey.
No.
We did surveys, you did not register, now you can't register. And then the last point, Mr. Sibbal said something which was disputed. Now let me show Mr. Mehta's admission. Turn to his counter, page 258. This is a bizarre situation. It's like chasing your tail. It's worse than chasing your tail. Please take give the counter, sir. 258. My time is limited. Please give the counter.
200.
This is an admission, even assuming Mr. Sibbal is wrong. I'm not saying he's wrong. This is an admission of Mr. Mehta. Just see.
Page 2.
258. And look at the clever language also he tries to use in the middle of that one.
Page
258 of the counter.
JPC report. Counter is not that.
Whereas admission has been called by the Privy Council as the highest degree of proof. You don't need to prove something which is admitted. I must kindly mark my 5 elements because they make a connecting arc. 36(1) registration. 36(7)(a) you cannot register.
36.
Well, just mark my arc. 36(1) everything must be registered. Shall, etc. Very clear ones. By this act, we're talking of this act now. 36(7)(a) collector has to allege one line. Everything stops. Forget 7. 7A only. 7A only.
Dispute.
And use the word dispute. Not a conviction, not an adjudicated dispute, not a decree, not an appeal, nothing. Collectors, one sentence, this is in dispute. I believe. Actually, what they say is, I believe this is government property. Now, 36(7)(a) stops 36(1). Then goes further. 36(10) says that you can't challenge this because you've not registered in 6 months. Now, this is amazing. Kindly read it. After, no can be commenced, etc. The last 2 lines. By any court after expiry of a period of 6 months from the commencement. That is November 25. Now, Mr. Mehta may say, read it like this or that. The statute doesn't read it like that. The statute is harsher than the kindness of Mr. Mehta. That's all I can say.
I read the
I wish he was the controller of all the works in this country. His interpretation may be more benevolent. I don't know. I can't take that chance, fellows. Either your lordship interprets it or the legislature writes it. Now see Mr. Mehta's admission at 258.
Mr. Mehta is never.
So the
58 is JPC report.
No, I mean Mr. Mehta. When I say
admit or deny. JPC
Mr. Mehta, we are sufficiently experienced to know that when you say Mr.
Mr.
Mehta.
He has much better things to do.
Now, Willis, he quotes the JPC report, his counter, and accepts that surveys is a farce.
It's an annexure.
Just note down, there are, as per him, 5 out of 28 states. Just note the figures first, then I will read it. 5 out of 28 states where there is survey. 5 out of 28 and 4 out of 8 union territories. Note these 2 figures once. The chart is given at 259 of Mr. Mehta's counter affidavit. 5 out of 28 states and 4 out of 8 union territories, and 9% of the total area of this country is represented in these 2 figures. Now, just look at this vicious circle of the 5 elements. 36(1), 36(7)(a), 36(10), and the survey. It's an impossibility. It's worse than chasing a tail. Now, in his favor, which he is not arguing, or he's not even today he's perhaps resisting. Let me say something in his favor. 3R makes a very clumsy attempt to not 3R, the proviso. 3R, the proviso, makes a somewhat clumsy attempt to save something, but puts the caveat of a dispute. Turn to 3R proviso. Turn to proviso. That is the harmony, my lords.
By now, we remember 3R, 3D.
Proviso. No, I'm on the proviso. I'm not on the main 3R.
Proviso.
Correct. My lordship had 3 days full It's come. Well, this proviso puts the same caveat of a dispute. Dispute is alleged. Then there's no, well, I can understand a decree. I can understand a primary adjudication. So whatever is attempted to be supposedly as partial saving is taken away. The caveat takes away everything else. Next point, Willis. Next point.
What is the meaning of easy in dispute?
There are, Malus, we filed a joint written submission, Mr. Sibbal, I and others, Malus. Just take the spiral for a minute. It will take half a minute only. Give the spiral, madam.
Yes, spiral.
The next point.
Okay.
At page 8 of this spiral, I'm sorry, page 6 of this spiral, I have cited the proposition on top, Malus, in small Roman 4, page 6. I just, to save it, I should be noting down and writing. Page 6. Apart from Ram Janmabhoomi judgment, apart from Siddiq, that has been cited many times. We had put in our submission, which is incorporated in the mega submissions. Small Roman 4. Additionally, and this has been your lordship's one-way consistent interpretation across India, consistently held by high courts, that the absence of registration does not affect the original character or status of a property as waqf. Now, Willis,
Where are you reading?
at page 6, small Roman 4.
Okay.
Two-line proposition. There are 4 cases from Karnataka, Kerala, Allahabad, and one more, Andhra. In the footnote, if my lord may just be assisted by noting the paras are not there. I've checked with the paras. Just note down the bottom of that, if your lordship doesn't mind. The first one is Allahabad, para 7 to 9. My apologies, or I can have it put with the court master. I don't, we should just very quickly. Para 7 to 9. Karnataka is para 3 bracket 1.
In the footnote.
Footnote or
So you have seen that.
Kerala is para 2 and 3, and Andhra Pradesh is para 20. These paras are not there, Malus. That's the fault. Can I repeat it very quickly and slowly?
Yes, please repeat the para.
Yes. The first is Allahabad, para 7 to 9. That is what is written as AHC, that's Allahabad, 7 to 9. The second is Karnataka, para 3 1.
31.
3 bracket 1. Both goes bracket. Then Kerala, paras 2 and 3, and Andhra, para 20.
Kerala, after Kerala, what is it?
Para 2 0.
So after Kerala?
Andhra, the last one. Andhra, para 20.
Unnecessary.
All that, we don't have time to argue that you can't reverse the judgment, you have to remove the basis. This is all just the blanket approach. Now, very quickly, you should sit for 5 minutes extra, if you doesn't mind. I'll be very quick.
Yes.
Now, Malus.
The
other second.
Let's have 10 minutes extra in the lunch recess. We are sat for 10 more minutes. So
that's not the reason I'm saying so. That's not the reason I'm saying so. That's not at all the reason.
Parity.
You were very generous with the time with us. Your Lordship sat long.
Parity.
No, that's not the reason I said. Now, Malus, my learned friend.
Yes.
My learned
In
friend.
fact, Manoj, both of them curtail.
He
didn't
Don't curtail his time.
That's the problem. Now, Malus, the second aspect, this registration is over, Malus. Registration is over. That arc is important. 5 facets. Vicious circle. You can't comply and you are making it impossible to comply. The second is this, Malus, my learned friend again gives much less than a half truth. He is again and again, Malus, violating or rather being Yudhishthir in his worst form. This Malus, a Muslim or professing the Muslim faith is a common phrase in any act which is religious focus. A Hindu may enter or a Christian may. That's the way it is used in the 23, 54, 95 and 2013. There is no act which says Muslim professing faith for 5 years and satisfy there is not a contrivance, reverse burden of proof. Not a single act. Act includes amendments. So it's a broad brush argument. It's always been there. It was there in 1913. It was there in 1923. So neither Muslim professing and practicing 5 years, the phrase absent. Second, contrivance is a reverse burden of proof, Malus. I must prove to him that I am not a contrivance, which is impossible. And Malus, to a collector who will make me go to his office for whole life. And then, Malus, it links, as I said in the opening, which I am not repeating. I am the only faith which is asked to do this. That's an Article 15 point directly, Malus. 15 is being underestimated. The Lordship has got 25 and 26. 15 is overarching. And the first of the 6 grounds there is religion. First word in 15 is religion.
That is already argued in the main.
So, Malus, no other religion is asked to show a practicing for 5 years or a contrivance reverse test. Malus, the Sharia was again a very misleading example. Malus, if I pass a Hindu Endowments Act or if I pass a Sharia Act, the first sentence of all these acts in all religions, Christian, Malus, Hindu, Jain, will be a practicing Jain. So the Sharia Act says practicing Islam.
Right, Sharia.
One second. Practicing Islam, it says.
Sorry.
And the conceptual difference, that's a choice I may make. Well, I may make a choice to go under Sharia law or not. That choice is based on my practicing Islam. That has nothing to do with the Waqf Act where they've said practicing Muslim for 5 years at least and show a contrivance. No such provision is there. Next point, well, my time is very limited. Retrospectivity has been argued. Note it affects in 2 or 3 areas. 36(1) is completely retrospective for all times. The language lordship has seen 36(1) is retrospective for all times. It says before or after, without time limit, And it then, this point about 9 and 14, I find it very odd, with great respect. My learned friend reads it as maximum. First argument is his benevolence cannot change the statute. You have no such maximum in that figure given at 2 Muslims and 3 Muslims for the council and the board. But what is more, the section has to be read only to add up. If the lordship next to section writes the number is clear. It gives a figure. Now that has been done. I am saying, your lordships cannot interpret this other than, in this manner. Just because his counter at page 75, the whole argument is based on his counter. He says, I read it as not more than 2.
No, JPC.
That will not be correct. Then, 2 more things and I am done. The Bombay Trust Act, section 31. Don't waste your time opening it. Please note it once. Is nowhere near 36, 7A or 10.
No, I read 31 just.
It is a 2-line provision. It has none of the barring effect of 3610 or 36.7. That's a wrong example. JPC point given is misleading. JPC, my learned friend waxes eloquent in his counter on JPC. That JPC, it heard so much, it spent so much time. My lords have said as a matter of law, I'm not arguing the facts, a very important thing is 11 dissenting notes, a lot of people not heard, those 2 clauses amendment did not come, that lordship was heard already. But as a matter of law, my lords has repeatedly said, and just note the citation to save time, Kalpana Mehta, 2018, 7 SCC, page 1. Kalpana Mehta, 2018, 7 SCC, page 1.
Importance of JPC.
Para,
we have appeared.
thank you.
Both of us were there.
Para 440, no, we were not in Kalpana Mehta, we were in the matter which
I was in Kalpana. Yeah, anyway, sir.
Para 449.6. Para 449.6 followed in the Delhi Assembly matter where we were both opposing each other. That was the matter. Then this says, the quotation only, note this para, any observation in a report or inference of a parliamentary committee, that was an assembly I think, cannot be held binding between the parties. But here it is worse, you had a huge number of suspended, 10 of the 31 members, no clause by clause discussion. 2 clauses came later. Keep that in mind. So JPC waxing eloquent is neither here nor there. Article 15 on both the example I gave, and in addition on 3E, excludes. That's my submission. I can only add a note of that. One last thing. Sorry, one last.
I'm the only
one last. No, one second. Well, I have not itemized. No, only 5 seconds. I forgot.
I remember Quran and
Let us listen to him for
No, 5 seconds. I forgot. Your lordship is being asked for a stay. Just for item. Your lordships can mold the relief. Your lordships can accept some, accept, not accept. Just for itemizing the relief, we want, subject to my lord's kind discretion, 3R deletion, 3R proviso. That's important listing. The lordship will not have the focus. The focus is, no, that's late. That's the capital C. That's coming up. 3 small r deletion, 3 small
or proviso.
3 small r, the deletion itself.
Entire or only proviso?
No. That second, deletion of the Waqf-by-user, that one line, I.
the 3R.
3R, then 3R proviso.
What is under
Let me please finish, sir. I am
Retain your lordship.
3R bracket I is the first. 3R proviso is the second. 3 capital C is the third. 3D and 3E are 4th and 5th.
4 and 9 and 14.
Then 9 and 14 are the council and the board.
108 immediately.
And 36 7A and 36 bracket 10. We're not arguing with 104 also, or should be added. That's been also. I'm very deeply obliged.
Don't forget to share your comments and subscribe to